Let me just quickly take our viewers right now through the challenges, the CBI challenges bail to Sengar. What all are the points that we're looking at, the focal points that we're looking at in this very case at this given point of time. The Delhi High Court order, legally unsustainable given the gravity of the offence. That's the first point that's been put forward by the CBI. Sengar's release, number 2. Sengar's release poses real risk given the influence that he wields. That is what Nalini, in fact, was also speaking at length about as to how the Delhi High Court has spoken about that very part, that for this very reason, security cannot be a reason to be holding back someone in jail at this point. Number 3 will again be the bail to Sengar, sending a troubling message in sex abuse cases. That is what has been leading to protests across the national capital and the country at this given point when we speak about the Unnao rape case verdict that's been delivered by the Delhi High Court previously, which is again being re-looked at by the Supreme Court today. Number 4, High Court has failed to adopt a meaningful interpretation of the POCSO Act, which is the main sensitive matter that we are speaking of. How is the POCSO Act being interpreted in this very case? That is something that the Supreme Court will have to relook again. That's again come in as what the CBI has challenged, how the CBI rather has challenged the High Court order. Number 5, convict Sengar doesn't fall in the definition of public servant. This point, this technicality has also been, which was earlier said by the High Court that he wasn't a public servant. That technicality has also been challenged by the CBI again in the very particular case that's been taken to the Supreme Court. Now, number 6, and what we see is that long incarceration cannot lead to lifetime suspension in heinous crimes. That is another particular point that's being looked at by the CBI, or rather challenged by the CBI in this very case. Let me quickly now take you through the account that's been shared by the victim of the Unnao rape case while she was having a conversation with our colleague Anmol Bali. Let's quickly take a look.
ये देश का पहला ऑर्डर है जो कुलदीप सिंह सेंगर को अपील रोकते हुए, निलंबित करते हुए, सजा रोकते हुए उनको छोड़ दिया गया। कुलदीप सिंह सेंगर के परिवार मिलने जाता है, कुलदीप सिंह सेंगर से मिलता है, लेकिन उसमें कुलदीप सिंह सेंगर लोग मिलके, भाई परिवार भी जेल में नहीं है, और लेकिन बाहर से सेटिंग बनाई गई। मुझे 1 करोड़ रुपए की ब्रजभूषण सैन जी को सुपारी उनसे कहकर सुपारी दिलाई गई ताकि रेप विक्टिम को खत्म करो और हम बाहर आए। और जज साहब बिक चुके, CBI का आयु बिक चुका है। आदित्यनाथ जी महाराज ने यही मेरी गुहार है कि मैं ऐसा कर दीजिए, ऐसे लोग को संरक्षण देना बंद कर दे, उनको पार्टी से निकाल दे। कुलदीप सेंगर एक विधायक 10-15 विधायक भेजिन, हम माँ बेटी को मारने के लिए आया था, मारी नहीं, हम तो माँ बेटी का पूरे परिवार का मार रहे, घसीट कुलदीप सेंगर ने भेज रखा था यहाँ जंतर मंतर में। हमको किनको भरोसा नहीं, अमित शाह के कही दिन जाए कि हमारे बच्चों को सिक्योरिटी देने, मेरे परिवार को खत्म कर दिया जाएगा, मेरे बच्ची को सेफ रखा जाए, मेरे सारे बच्चों को।
With that, viewers, let me quickly cut across to Nalini Sharma and also Anisha Mathur, who's joining us from the newsroom at this very given point of time. Anisha, I'll first quickly come to you for a response with regards to what exactly are we looking at in terms of the interpretation of the POCSO Act in the verdict that was given by the Delhi High Court in this case. Just a brief response in terms of how has it been looked at and what is the CBI now asking for in terms of a reinterpretation of that very act in this particular case today.
Let's look at how the High Court had passed its judgment. The High Court in its judgment had cited a 1984 judgment of the Supreme Court claiming that MLAs is not a public servant within the definition of the IPC and therefore the POCSO. What is a public servant under the IPC is defined under this law, where a public servant is somebody who is employed by the government or is paid by the government. Now, in that judgment in 1984, it was said that MLAs are not public servants, they are elected representatives. The CBI in its arguments is saying that that interpretation is completely incorrect. In fact, in the 1997 LK Advani case and after that in the Sita Soren case of 2024, the Supreme Court has already said that MLAs are in fact public servants within the definition of the Prevention of Corruption Act, and therefore when two definitions are available, the High Court should have looked into the larger definition, including MLAs, in the definition of a public servant. Now, this question is going to have to be decided by the Supreme Court here, because remember, it is the law and how it defines it that has come into question, and that is why the questions are being asked: are legislators shielding themselves? Because it is the parliament which passed these laws. The parliament in the POCSO Act, even in the 2019 amended definition, simply said that the same definition as IPC will apply, not the definition of the Prevention of Corruption Act. And that is where exactly the CBI is asking now that High Court has erred in law, and I'm quoting the CBI, by failing to adopt a purposive interpretation that advances the objective and intent of the POCSO Act. The POCSO Act is a victim-centric legislation enacted to protect children from sexual offences, and the legislature has therefore provided for stringent penalties, protective safeguards for persons in position of authority or trust, which is where this definition should have been done by the High Court, that even if he's not a public servant, he should have still been included as a person in position of trust or authority, and that is why he should be given the aggravated sentence, and therefore he is not entitled to any relief as far as bail is concerned. That is the argument that the CBI is going to take, has taken in its petition that is there, that there has to be that it is important to hold those who are in position of authority to a higher standard. It is required to hold them accountable, and that is why MLAs, MPs, government functionaries and other persons who are exercising a public function, remember, public function is where the CBI is arguing that they should be treated as public servants or as persons in authority wherever the abuse of their office is concerned. And that is why the CBI is arguing that because Sengar used his power, used his authority to not just do the act that he did with this child, he also used his authority, abused his authority to prevent the FIR from being filed, to ensure that her father was also arrested and then died in custody. So with all of that in mind, the CBI is arguing that the High Court should have kept this entire big picture in mind, especially since this case involves sexual assault on a minor who was she was just 17 years old, and the court has also the CBI has also arguing that this argument by the High Court that he has spent 7 years 5 months in jail is irrelevant, since Sengar is facing a life imprisonment. And in cases like these, in POCSO cases where a child has been violated, where there are significant threats to the child and to the family of the victim because of the power and influence of the accused or the convicted person, the High Court should not have given any benefit to Kuldeep Singh Sengar. Now, as my colleague Nalini was saying, we're waiting we're waiting for the bench to assemble. We're still, the bench is yet to assemble. The Solicitor General is in the courtroom to present the arguments on the side of from the side of the CBI. The victim's lawyer is also present in the Supreme Court courtroom number 1. But these arguments will be very, very important. Why did the High Court give this benefit that, well, you've served more than 7 years, and therefore
right, Anisha, yes, so we understand, and we understand what exactly is the POCSO Act interpretation that's been challenged by the CBI, and it's a very important part, viewers, that we're taking a look at in this very case.